the inauguration of the Andhra Pradesh Judicial Academy, Chief Justice of India CJI Chandrachud reiterated his stance on perhaps the most fundamental rule of the justice system, bail but not jail. He raised his concerns over the sheer magnitude of under-trial suffering in prisons and how it was deprivation of liberty for a single day is a day too many. He also claimed that there was a sense of fear among the courts on how the grant of anticipatory bail or a normal bail will be perceived at the higher level. He went on to add that trial court judges have been pulled up for grant of bail in certain high courts, and the performance of judges has been analysed on the basis of their conviction rate. Chandrachud also revealed that he had called upon the Chief Justices to ensure that such practices are done away with. As per the National Judicial Data Grid, or the NJDG, over 63 lakh cases are considered to be delayed due to the non-availability of a counsel, and over 14 lakh cases are delayed because they await some kind of document or record. Speaking about district courts, he asserted that Section 438 of the CRPC and Section 439 must not be meaningless, mechanical, or for that matter, procedural remedies which are perceived at the grassroots level at the district judiciary only to get a rejection and then move to a higher court. My colleague Harish is joining us live to get us more details. Harish, thank you for speaking to us at this very important subject that we are tracking at this hour, is where Justice Chandrachud has emphasized on bail and not jail being the basic premise of the criminal justice system. This is something that may draw a straw with the law minister, who had recently emphasized on the fact that the court must not while away its time listening to pointless PILs and bail pleas.
Yes, bail but not jail should be the norm, and this fact has been reiterated by the Chief Justice of India, CJI Chandrachud. He was in fact inaugurating a judicial academy in Andhra Pradesh's Amravati. In fact, to stress the importance of how important granting of bail is also not only for personal liberty but also to decongest jails. The Chief Justice said that around 66% of, in fact 77% of India's prisoners are under trials, and they languish in jail only because the trial courts, high courts, and also the Supreme Court is taking time to process the bail applications and reeling out more statistics. And as rightly put, the Chief Justice also said that there are around 66 lakh cases languishing just because there are there are no counsels in that matter, and 14 lakh cases are such in which there are some documents for want of documents. So, in a way, the Chief Justice is stressing on expeditious trial, expeditious grant of bail, and these statements are very important also in the context of recent statement by the Law Minister Kiran Rijiju, who had questioned why the Supreme Court is wasting time hearing bail applications and frivolous PILs, while it should focus on bringing down pendency of around 70,000 in Supreme Court, and also rather focus on bail and constitutional matters, because Supreme Court is a constitutional court. So once again, Chief Justice of India CJI Chandrachud emphasizing the fact that hearing of bail is very necessary. It protects not only the right to life but also personal liberty of a prisoner. And Chief Justice Chandrachud also, with a note of concern, he also stated that 4 years ago, Supreme Court had ruled that the subordinate courts, high courts and Supreme Court should be liberal while granting bail to persons who are booked for offences in which maximum punishment is 7 years, and if they have spent 2 to 3 months in jail, their bail application should be considered very leniently. But this has not percolated to the ground. Justice Chandrachud said that even now the Supreme Court's order in this regard is not being implemented by the trial court and several high courts, which are proving to be very stringent as far as grant of bail is concerned. So, very serious and significant observations made by Chief Justice of India D.Y. Chandrachud, and as you rightly said, once again emphasizing that bail and not jail should be the norm. Back to you.
Well, Harish, appreciate you joining us with all those details as Justice Chandrachud Singh underlines and emphasizes on the need for bail and not jail being the basic premise of criminal justice system in India.